For those of you who participated in our coronavirus webinar last month, or if you've been following our FAQs on the website, you all know some of this, but I want to go back to the beginning, fill in the blanks, and share some of the things that we figured out in the last month. Just as a reminder, let's look back at how we got here to our virtual meetings. On Friday, March 13th, just over a month ago now, the governor declared a state of emergency and temporarily closed down our schools. I suspect other attorneys immediately started getting calls and emails from around the state asking whether board meetings could be held electronically. And on that Friday, the answer was no. Nothing in that emergency order said we could, and nothing in our Open Meetings Act said we could. And so we reached out to Dr. Mackey's office and also to Governor Alvey's office, and we very quickly got some relief in the form of the governor's first supplemental order, which permitted virtual meetings. And a couple of weeks later, they also addressed board hearings that were scheduled to take place. So today we're going to go over the details of both of those orders so you know how to handle them. The first supplemental order was issued on March 18th. The part of that order that deals with virtual meetings is here. I've screenshot it for you, but you can also find that entire order on our website. So what did this first order do? Of course, it gave school boards as well as city councils, county commissions, and other public bodies in our state the ability to meet electronically. Specifically, you can establish your quorum electronically. You can deliberate, that is, discuss matters that you're going to vote on electronically, and also take action. You can vote electronically now. The methods that you can use to do this are by phone conference, using video conference software like Zoom or any other method that allows the board team to hear each other at the same time. I take that last point to mean that emails and text messages are not appropriate methods of communicating for purposes of having a virtual meeting. Of course, this order does have some limits. The only actions that you can take are those necessary to respond to COVID-19 issues and actions necessary to perform essential minimum functions for your board. The order doesn't define that phrase for us, so the guidance that we've been giving is this: can the action that you want to take wait until you resume live meetings? If it can't, go ahead and take the action. So this can be personnel actions that we need to take, approving a contract, or dealing with a lawsuit, things like that. It's anything your board needs to do to function. We only ask that you respect that limitation and not abuse it, because we asked for this flexibility and we got it, but we don't want to abuse it and then potentially lose it. We got a question from one board that was preparing for superintendent interviews when all of this happened. They asked if they could conduct interviews electronically. Our answer to that is yes, because hiring a superintendent and the tasks that go along with that are things the board has to do to function. Of course, it's probably not a great idea to hold those interviews in person, even if you can socially distance, because if a candidate declined to show up in person under these circumstances and then they were penalized for that, I'd be worried about being able to defend that position. Also, we reminded them to allow for the fact that some people struggle with this particular medium, so consider showing a little bit of grace in how people perform here. The other thing the order requires is that if you do hold a virtual or electronic meeting, you have to post a written summary of the actions taken to a prominent location on the system's website within 12 hours of the end of the meeting. That summary should reflect the deliberations conducted and the actions taken with enough specificity that the public can understand what happened during the meeting. That does not mean you have to have a transcript of your meeting, but you should have a solid description of the items discussed, any issues that were raised, and how each board member voted. If you don't have a website, the summary needs to be provided in any other manner that the public can reasonably see it. Some alternative examples of, not putting it on your website or putting it somewhere else could be posting the summary to the system's Facebook page or Twitter page or sending it to the local media. Make sure you get this posted even if the public was able to watch or listen to your meeting live. I will give y'all an example of maybe what a written summary might look like later on in just a few slides. What about public participation? The order says that the board should use a method that allows the public to hear or view the live meeting, but that is not required. If you do allow the public to participate, two tips. You need to put the call in or access information in your meeting notice, and I'll give you an example of what that might look like later. Also, we would suggest that you eliminate the public comments portion of the meeting. First, I'm not sure that public comments fall into the category of minimum essential functions, but also we've seen multiple instances of trolling during virtual meetings around the country. Obviously, people can take advantage of their anonymity using this kind of software. And if you permit public comments, it may be physically difficult to figure out who's doing it and shut down their access while you're in the middle of a live meeting. Of course, just because we've been given this flexibility, we still have to comply with the regular parts of the OMA. We have to provide notice of our meetings, whether or not the public will be able to hear it or view it. So even if you're gonna have a meeting where you're not allowing public access, you still need to provide this notice. We still have to have a quorum present and participating in our meetings. Even if that's electronically and by phone, we still have to have a quorum. We need to make sure it's clear who is voted for what. So you may want to go to a roll call vote if you don't already do that, so the votes are clear to the secretary or whoever the person is taking your minutes, especially if you're on a phone conference. But even if you're using a video conference, don't assume that person is staring at the screen and reading people's lips and trying to make sure that the votes are properly recorded. So think about doing a roll call vote during this time. Votes still have to be by a majority of the whole board, not just the majority of those participating. So make sure you still do that. And obviously, we still have to take minutes, even though we're doing a written summary. Those are going to be two separate documents. They may be similar, but they're not the same. Your written summary will probably have a little bit more detail than your minutes will. Also, you can still go into executive session if you need to, and you have the reasons to do so under the law, but you still need to follow the regular steps to do so, including making the motion, stating the statutory reason like good name and character or pending or potential litigation. You can still have to vote and do your statement of reconvention. It's probably best to do your executive session at the end of your meeting if that's possible, so the public can simply disconnect from the call rather than hold the line or stare at a blank screen. If the public is listening or watching, hopefully you're using software that will allow you to limit executive session to your board team, superintendent, and board attorney, depending on who all's involved. But someone needs to figure that out and test it ahead of your meeting so you know how that's going to work. Also, if you do have that kind of functionality, make sure you send written instructions to your board members and your board team ahead of the meeting so you can have a smooth transition into executive session. Finally, you probably want to have a staff member dialed into the public portion of that meeting so they can alert the superintendent or the board president immediately if your instructions fail. You don't want to think you've gone into executive session, but the whole thing is still being broadcast to the public. So let's look at some of the sample documents you all might be using for these meetings. Here's a sample notice for a virtual board meeting. It has all the same things you normally include, like the date, the time, and what you expect to discuss. But you'll also see the items highlighted here in yellow, in yellow that you can add, including the fact that you're relying on the governor's order to meet this way, the method that you're going to use. Here we're doing phone conference. And the note about your written summary. Here in yellow, the summary of the actions will be posted to the system's website within 12 hours. If you're also going to permit public access, you can add the language like the language in green to tell the public how they can join your meeting. Speaking of the written summary we mentioned a few minutes ago, let's take a look at what that might look like. Again, this will look similar to your minutes, but it'll have more detail. For example, look at the second bullet here. You'll note that it generally discusses the discussion in yellow without being a transcript. Here, Ms. Green, Mr. Yellow, Mrs. Blue spoke in support of providing students with the technology necessary to participate in distance learning, but Mr. Purple was concerned that the contract was not bid. Attorney Pink reminded the board that bid requirements are suspended during the state of emergency. So this is not a transcript of what these board members and the board attorney said, but it does give the public an idea of what that discussion, how that discussion went. But what about your minutes? Again, the minutes will look like your regular minutes, except you'll note the method used. Here we've said that we're meeting on this date at this time via phone conference. As always, you'll record those present and absent, what the superintendent recommended, and how each board member voted. Before I finish up, we got one other order that I mentioned from the governor that was helpful. On April 2nd, the governor entered the 5th supplemental order that said we can delay any hearings that we have pending in the interest of health and safety. For us, this might be an expulsion hearing or an employee termination hearing. This order does not require us to delay these hearings, but personally, I had been concerned about requiring students or employees or even witnesses to show up at in-person hearings. I questioned whether we could order them to appear at a live hearing during the pandemic or otherwise waive their rights. I think that would be fundamentally unfair, and no matter what the person did to earn their discipline, that would probably be challenged and we would potentially lose that argument. I think that's true even if we were able to use social distancing during those hearings. So this order lets us just maintain the status quo. Of course, that means that we'll have some employees getting paid longer than they should. But as we've seen in some other situations in the last few weeks, some things that are going to happen during this school closure are not fair. And I feel like we feel like we just have to suffer through those things and get to the other side. I've been asked whether we can hold virtual hearings, and I think you probably could, but the benefit of live in-person hearings is that board members can look witnesses in the eye and see how they react or see how they carry themselves. And you really lose that in a video conference. So I don't think that's personally a viable option, but that does remain an option for you. Here's a sample letter that can be used to cancel a hearing if you need to. It advises, of course, that you're canceling the hearing, why you're canceling the hearing here for health and safety, your authority to cancel the hearing, again, pursuant to the governor's order, and what will happen next. And also that the employee here in this example will remain in their current status. Remember that we still need to send these via certified mail like normal notices, but because some attorneys are not working in their offices every day, make sure you also email and or call people to make sure they know about the cancellation. I just want to remind you all that our COVID-19 webpage is where you can find all of the orders that impact public schools, and all the FAQs that we collected to deal with the shutdown are there. You're always welcome to reach out to me with your legal questions, and as always, call your attorneys early and often for legal advice. Thank you.